आप इसके पहले किसी इंटरव्यू में अपीयर हुए?
No, sir.
First
This is my
appearance?
first.
And first attempt?
Yes, first attempt only in first interview.
थोड़ा सा सोच लेना सवाल का जवाब देने के पहले। जैसे फॉर एग्जांपल मैंने जो आपसे सवाल पूछा था, शादी हो चुकी है, शादी होने के बाद मैंने गाड़ी मांगी,
इनको लॉ का नॉलेज काफी बढ़िया है, तो उसमें कोई प्रॉब्लम नहीं। आप बहुत काम है, आपने सारी चीजें परफेक्ट है, बस थोड़ा सा अपना पिच बढ़ा लीजिए।
और पिच मॉड्यूलेशन की जो ये बात करें तो आई वुड से दैट यू हैव ऑफिसर लाइक पर्सनालिटी और यही जजेस देखना चाहते हैं।
May I come in? Shall we sit? Good afternoon, sir. Good afternoon.
So your good name is Priyanka.
Yes, ma'am.
So Priyanka, please tell us about yourself.
Ma'am, my name is Priyanka Bajpai and I am currently living in Bhopal. I have done my schooling from Balaghat English Higher Secondary School, Balaghat, MP. And then I have completed my BA LLB Honours from Institute of Law, Nirma University, Ahmedabad. Thereafter, after graduating in the year 2022, I have been preparing for Judicial Services Examination and this is my first attempt in RJS.
बालाघाट के मेजर ट्राइब्स बता सकते हो?
Ma'am, it is Gond and Bhil, but it is not found there majorly and it is a small town in MP.
और राजस्थान में कौन से मेजर ट्राइब्स हैं?
Ma'am, I am unaware about it right now. I'll surely read about it.
आपको जुडिशरी में क्यों जाना है?
Ma'am, I drew inspiration from my grandfather. He was retired district and session judge of Raigad. And then the integrity and the dignity attached to this post really attracted me to join the service. Also, this post gives us the opportunity to apply my knowledge of law and to give justice to the masses. That's why I was attracted to join judicial service.
आपको लगता है this application of knowledge of law cannot be applied to any other profession?
Ma'am, it can be applied, but different profession demands different work culture. So as advocacy also deals with justice delivery and it is a step towards getting justice. However, as a judge, a judicial officer himself dispenses justice while taking into consideration different parties in their matter. So that's why.
ये बताइए कि आपके फेवरेट सब्जेक्ट क्या है?
Sir, I have read all the subject for my preparation, but the favorite is IPC.
Okay. What is the difference between common object and common intention?
Sir, the major difference is that in common object there is a premeditated arrangement of or meeting of minds before doing the criminal act between two or more person. Whereas in common object there are 5 or more person and they act in persecution of their common object. The common object is defined under 141 of IPC. There are 5 common objects. If the 5 or more people agree to do those acts in persecution of those 5 objects, then it is under common object.
Okay. भारतीय न्याय संहिता और भारतीय दंड संहिता में क्या अंतर है?
Sir, Bharatiya Nyaya Sanhita is recently enacted act which repeals IPC and it is majorly the criminal law only which repealed the earlier IPC, Indian Penal Code.
तो ये नाम बदलने से क्या अंतर आया?
Sir, the major object of enacting this law was to repeal all those colonial features which are present in IPC. So that's why, and also one more reason was to inculcate different new offences which are there now in our culminating society.
आप कुछ बता सकते हैं क्या क्या चेंजेस आए हैं?
Yes, sir. There are 2 or 3 new offences which are added, such as snatching, organized crime, petty organized crime, terrorist act. These are the few I can recall, right?
आपका कहना है कि colonial features को हटाया गया है, तो can you please describe a few colonial features of Bharatiya Dand Sanhita, that means Indian Penal Code, which has been repealed?
Yes, sir. Sir, there are some of the provisions which define queen, government servant. These are the provisions which are repealed, and also the primary object of Britishers to enact Indian Penal Code was to punish the Indians for the wrongdoings. Whereas we have changed it to Bharatiya Nyaya Sanhita because now our object is to give justice to the masses, not to give punishment. It also reflects our change in mind or change in legal theory towards restorative justice.
एक डिबेट ये भी थी कि सेडिशन इज अ कॉलोनियल प्रोविजन, तो उस कॉलोनियल प्रोविजन के रिस्पेक्ट में हमें सेडिशन हटाना है, क्या सेडिशन हटाएगा?
Sir, in BNS, the Bharatiya Nyaya Sanhita, the provision of sedition is repealed now, and a similar provision is enacted, but it is not exactly sedition.
So, are you aware of that provision?
Yes, sir. It is, as far as I can recall, it is Section 153 of BNS, which talks about harming any act which harms the government of India.
तो अल्टीमेटली मतलब ये एक तौर पे सेडिशन है.
No, sir, it is not exactly sedition, but people and critics are saying that it is in lines of sedition.
Okay. Fine. कॉमन इंटेंशन कॉमन ऑब्जेक्ट के रिस्पेक्ट में आपने बताया. कॉमन इंटेंशन के रिस्पेक्ट में व्हाट डू यू मीन बाय कॉमन इंटेंशन? थोड़ा सा आप इलैबोरेट करेंगे?
Sir, common intention is defined under Section 34 of IPC, and it means two or more person doing a act, one or several person doing an act in furtherance of their common intention. Common intention is a premeditated act. When two or more person agree that we will do a criminal act in certain manner and certain means, then it is common intention between both of them.
Okay. So, is active participation is a necessary ingredient of common intention? Section 34.
No, sir. As far as I can recall, yes, it is. The active participation must be from all the members, whereas in common object, it is not required.
So, what is the difference between an overt act by a member of that intention and an active participation? दोनों में क्या difference होता है?
Sir, overt act itself means certain act which is done by the person himself, whereas active participation can be through just merely standing and guarding the entire criminal act which is done by others. So this is also comes under the category of active participation.
Okay. Is physical presence necessary for attributing the liability with the help of common intention?
No, sir. If a person is mediating through while staying at another place also, then also it can be called that he was
I'll
doing it.
give you two situations. In one situation, I'm over a call and you guys are there, मतलब आपके साथ दो और आपके मित्र हैं, और वहाँ पे मैं आपको गाइड कर रहा हूँ कि you have to execute this task. मैंने आपको वो टास्क एग्जीक्यूट करने के पहले भी फ़ोन कॉल किया और मैंने आपसे पूछा कि is everything okay? एक चेक लिया मैंने, but then you guys executed the task. Can you make me liable for the act done by you guys with the help of common intention?
Sir, I think there is a active participation because the person is mediating and there is prior meeting of minds between all those criminals and the person who is talking on the phone. So that's why common intention will be applicable.
Now, for example, आप एक जज हैं, आपका एक लॉ क्लर्क है. लॉ क्लर्क के रिस्पेक्ट में वहां पर उसी का एक रियल ब्रदर कोर्ट रूम में आता है एंड ही हैज फाइल्ड लाइक ही हैज प्रोसिक्यूटेड समवन, और उसके रिस्पेक्ट में वो प्रोसीडिंग्स आपके कोर्ट में चल रही है. आफ्टर कंप्लीशन ऑफ द हियरिंग, both you and your law clerk went inside of your office, and then both of you came out and you pronounced the judgment of conviction with respect to the person who was prosecuted by your law clerk's friend या फिर law clerk's brother. So, will you do this?
Sir, as far as I believe, I will be holding the chair which is known for pronouncing justice. So whatever the fact and circumstances will appear before me, I'll decide according to that, not on the basis of the relationship which my clerk is having with that litigant.
क्या आप जज अपने पर्सनल सेटिस्फेक्शन के लिए बनते हैं या फिर उनके सेटिस्फेक्शन के लिए जो आपके कोर्ट रूम में आए?
Sir, for the masses, for the
masses.
litigants.
So don't you think the masses will have a doubt in their mind? Something might happen inside the office, and then the judgment was delivered in the favor of the law clerk's brother. Although आपने अपनी पूरी निष्ठा के साथ अपने कर्तव्य का पालन किया, but will that a question arise in the mind of the masses?
Sir, I think every judgment and every order of of a court has its own critics and persons who favor those judgments. So I think there will always be a conflict in this matter. So I will try to be impartial in that matter, in that manner.
Okay. Chaliye. Any other subject which you have read?
Yes, sir, I have read all the
CRPC?
subjects. Yes, sir.
Can you please tell me when does a trial ends? And
Sir, when the recording of the witness is done and all the evidences are done, and then the judge, the matter is made for is kept for giving the judgment, then it is called that the trial has been completed.
so like मतलब कि the trial comes to an end before pronouncement of judgment. Is pronouncement of judgment not a part of trial?
Sir, it is.
Okay. Any recent judgment which you are aware with respect to a trial? When does it end?
No, sir, I cannot recall it right.
Okay. Additional prosecution क्या होता है?
Sorry, sir.
Additional prosecution in CRPC.
Sir, I am unaware about it.
Okay, one last question from my side. How many times does a court take cognizance of an offence? मतलब how many times the cognizance of an offence is taken during the course of court proceedings?
Sir, cognizance can be taken in three ways. First is
No. How many times? 3 ways we are aware. My question is कितनी बार एक अपराध का संज्ञान लिया जाता है?
Sir, once when the charge sheet is filed in court or complaint is given.
Okay. So अगर कोर्ट ऑफ सेशन के पास केस को कमिट किया जाता है तो क्या कोर्ट ऑफ सेशन उस केस का कॉग्निजेंस दोबारा लेती है नहीं लेती?
Sir, it does. When the committal proceedings takes place, then the court of session takes cognizance on the matter.
So can we say that the cognizance taken twice in a court proceeding?
Sir, it is a part of a similar, the same proceeding. So it cannot be said that it is done twice, I think. I believe so.
Oh, that's it.
ये बताइए कि कॉज और मोटिव में क्या डिफरेंस होता है?
Sir, cause is the external reason or the external factor because of which an act has been done, and motive is the internal object which a person seeks to achieve by doing a criminal act. So that is the difference.
Okay. And motive and intention में?
Sir, motive is the external object which a person seeks to achieve by doing a criminal act, whereas intention is his internal belief, the way he wants to achieve the object is his intention.
आपने मोटिव को क्या बोला भी कि
external factor or the reason why he wants to achieve that object, and intention is his desire to achieve those objects.
चलिए, what do you mean by police officer under section 25 of Evidence Act?
Sir, the police officer is any person who has been designated as police officer, and also some of the officers under different acts like NDPS and Excise Act and Customs Act.
Okay, preamble याद है आपको?
Yes, sir.
आप सुना सकती हैं?
Sir, I'll try my best to recall it. We the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to ensure among the people justice, social, economic, political, equality of liberty of faith, belief and expression, and equality, and to promote them among them all fraternity. And we give to ourselves this constitution on 26th of November 1949.
Belief और faith का क्या difference है?
Sir, belief is what person has the cognitive things which a person believes. It can be general or with respect to any matter in his life, whereas faith is basically spiritual or the religious matter in which he believes.
Okay. Marital rape का इंडिया में क्या status है?
So right now it is not criminalized and it is not punishable.
Okay, तो अगर कोई हस्बैंड अपनी वाइफ के साथ जो कि 18 साल से कम की नहीं है, अगर इंटरकोर्स करता है बिना उसके कंसेंट के, तो क्या इस चीज को कहीं पर भी कोई ऑफेंस नहीं माना जाता?
No, sir, it is not expressly an offense, but in case of judicial separation, if the husband and wife are in judicial separation and then the husband commit without her consent, then he can be made liable for the offense of rape.
ओके क्या इसको डोमेस्टिक वायलेंस माना जा सकता है?
Sir, the definition of domestic violence includes sexual abuse also. So it can be included, I believe so.
What do you mean by cruelty?
Sir, cruelty is defined under 498A explanation, and cruelty includes a physical pain or bodily injury which is given to the victim, and also the mental factor or harassment which can be done against the victim.
Okay. Does it include any unlawful demand?
Yes, sir, it can be for unlawful demand of dowry.
Okay. Does unlawful demand merely mean dowry or anything else also?
Sir, it can be for any valuable product or any other thing also, not just that.
What if, like, a person gets married to a woman and post marriage the husband start demanding a car शादी के बाद, because of that pressure the wife committed suicide, will that amount to a dowry death?
Yes, sir, it will be. Because dowry death also includes within the 7 years of marriage if husband or his relative commit any kind of harassment due to which wife commits suicide, then it is dowry death.
इसको लेके कोई presumption है?
Yes, sir, it is given in Indian Evidence Act, section 113B.
Okay, 13A and 13B में difference क्या है?
Sir, as far as I can recall, 113A it's regarding abatement to suicide, and 100B is for dowry death.
तो सर ने जो क्वेश्चन पूछा था आपसे उसमें कौन सा प्रिजम्पशन लगेगा, 13A और 13B?
Sir, 13B, because it is a case of dowry death only.
Okay, तो abatement of suicide नहीं होगा?
Sir, it is one of the element, but it is not the ultimate offense. So I think the ultimate offense is dowry death. That's why 113.
तो हम दोनों ही presumption यूज नहीं कर सकते?
Sir, I believe not. Only 113B.
ये बताओ, सेक्शन 73 ऑफ इंडियन एविडेंस एक्ट किस बारे में बात करते हैं?
Ma'am, I'm unable to recall. Sorry.
मान लो there is a case on 138 NIV और वहाँ पर accused का ये कहना है कि सिग्नेचर उसके हैं लेकिन जो अमाउंट है वो उसने नहीं भरा है, एंड हैंडराइटिंग एक्सपर्ट को बुलाने की जगह क्या ट्रायल खुद उस हैंडराइटिंग का एग्जामिनेशन कर सकते हैं?
Yes, ma'am. Now I remember the section is 73 of our Indian Evidence Act, which talks about the court can also compare the handwriting of any document. So yes, court can also
There was
examine.
a recent case of Rajasthan High Court on this. You recall me?
Sorry, ma'am, I'm unaware about it. I'll read about it. Sure.
Appellate stage पे additional evidence which is not based on merit, क्या court entertain कर सकते हैं?
Yes, ma'am. In appellate stage also, additional evidence can be taken. In case that there are 3 conditions in which it is acceptable. First is when the lower court does not have admitted that evidence which was likely to be admitted. Second, the party proves that despite due diligence, it could not bring the evidence in the lower court. And thirdly, the appellate court itself finds that such document or evidence is necessary for the final pronouncement of judgment. So in these 3 cases.
Thank you.
Thank you.